103, evidence defined. 115, one defendant, multiple counts. And then the substantive would be 1010, 1010, first-degree intentional homicide. For obstructing, the state asked for 1766A, defense said 1766. I'm not sure what the difference is, if there is any significant difference. That Either of you look at that and decide what you thought was different between them, or looking right now on the computer?
Your Honor, I believe 1766A, because that's specifically giving false information, so I believe that's the correct one.
All right. You both agree, I think, on 570, conspiracy as a crime.
Okay.
1750 for the perjury.
Yep.
140 for burden of proof and presumption of innocence. 145, information not evidence. 147, improper questions. 148, objections of counsel, evidence received over objection. 150, stricken testimony. I remember in the transcripts I read there was a little stricken testimony by Judge Hinkvis early on in the trial.
Mm-hmm. Yes.
155, exhibits. 157, remarks of counsel. 158, recording played to jury. 160, closing arguments. All right, 161, agreed testimony.
Agreed facts.
And on that agreed testimony, am I to read, you got one agreed fact that talks about Kathy Friday. And then you got one that talks about the evidence collected from the scene. Am I to read the paragraph from the Friday agreed facts and then from the evidence agreed facts?
Yes, Your Honor.
And should I just read the exact bodies of the documents and stipulations you filed?
Yeah, we had that read in the beginning of our case, so it went into evidence. So, yeah, we'd stipulate to you reading it in that manner now.
Okay. I'm sorry. So there's 161 agreed testimony. What, I think that's out. We agree that's out?
Correct.
Yeah, it should be 162.
Right, 162 is agreed facts.
Correct.
Okay. All right, run this over to Marcia, who I hope is still here. Yep. And so for the statement of the agreed facts, it's that paragraph right there, and those two paragraphs right there.
You want it on here?
Where it says state the agreed facts. Yep, thank you. 165, judicially noticed facts. I don't remember anything from the transcript or my part of the trial, so that's out. 170, circumstantial evidence. 180, statements of the defendant. 190, weight of evidence. 195, jurors' knowledge. 200, expert testimony. Then is the state defense going to be asking for 315? Defendant elect not to testify?
Yes, Your Honor. And we'd also be asking for 275, which I believe is the cautionary instruction.
Hold on, 275.
That's evidence of other conduct.
don't have that in my binder. Was that in the original list?
It wasn't, Your Honor, but based on, I think I submitted my jury instructions prior to the other acts hearing, so I don't think I must have forgot to amend it after that, Your Honor.
So it's 275?
Yes, sir.
All right, so that has a lot of blanks you have to fill in then. So does everyone have 275 on their screen?
Yes.
Yes.
So the second line, second paragraph, specifically, evidence has been presented that the defendant then described conduct. All right, who wants to propose the described conduct? Or do you want, yeah,
Your Honor, I was just pulling up Judge Hinkvis's order, because I believe he outlined the, I just want to make sure we're using the same language in his decision.
anyone know Marcia's number by heart?
4121? That's scary.
And hi, Marcia. Is that 275 we're talking about? Yes. Marcia, could you print me up a 275 and send it back over here with Ally right away? Thanks.
Yeah, about 5 years.
Oh. Each of you, so you can look at it in paper form.
Thank you.
I'm sorry, that was 4126? What was that again?
4121.
Oh, thank you. Send over an additional 2 copies for the attorneys, okay? So send over 3 of 275. Thank you.
As far as how to phrase that, there are 3 bullet points in Judge Hinkvis's decision in order on pages 3 and 4 that reference Ms. Ingalls' anticipated testimony. I would propose just using that language verbatim.
All right, so let me find that then. I've got to, and then can you give me about, do you know what the number of that order is or when about it was?
It's document 85.
Thank you. And where are the bullet points in the order you're talking about?
Bottom of page 3, top of page 4.
Okay,
There's
gotcha.
3 of them.
So one starts, the defendant's daughter, Lisa Masti,
No,
Whoops.
that one was excluded.
that was excluded, so there.
I think,
Oh, I see, I see there's many more than 3, so you're saying you want to pick 3 of these?
Just the 3 that reference Ms. Ingalls.
the bullet points, starting on page 3 and then top of page 4 would be
Oh, yeah. Oh. All right, I'm having a hard time hearing you. So at the bottom of page 3, the one that says the defendant's former wife, Darlene Ingalls, that bullet point?
Yes?
Yes, Your Honor.
Okay, and then the next two, you say?
Yes.
Yes.
So they all start with Darlene Ingalls?
Yes.
We're also, yeah, okay. All right. Okay, so that would go in where we see the first, did you give them each attorney one?
Yes.
So that would go where the first part where it says describe conduct.
Correct.
Okay, where's mine? Misplaced already, did I open this up? Oh, 75, thanks. Oh, 2 pages, thank you. Okay, so that's 3. Okay. All right, then next we have to choose the conduct, choose only those that apply. Do we have an agreement what they are?
I agree with counsel. On page 6 at the bottom, I think the basis for admitting the evidence was motive, intent, and absence of mistake or accident.
Correct, Your Honor. That was taken directly from the order. I think we want to stick as closely with that order as possible in the language of the jury instruction.
So we strike the rest. We leave in motive, intent, and then absence of mistake or accident?
Correct.
Okay. Okay. And we obviously have to delete the under definitions. We take out all the definitions except those for motive, intent, and absence,
Yes.
Yes, Your Honor.
mistake. Thanks, John. All right, anything else in the form then?
I don't believe anything else on 275, Your Honor.
Okay. Okay, Marcia. So what do you got there?
162.
Okay. Yeah, take that out. All right, so Marcia, for 275. I'm going to give you this copy of the judge's, I think this is order. And so, where it says add 3 dots. You don't have the dots, by the way, but these are the 3. So this is 1. Go like this then, okay. 2, and 3. So those 3 paragraphs are going to go here where it says, evidence that presented that the defendant, and you would write in these 2 paragraphs.
Okay.
These 3, so 1, 2, and 3, okay? And the rest is struck. Next, we're on to 247. Verdict as the defendant only. Who asked for this? And
I think it was the state. I mean, there's a charged co-conspirator, so just to clear up any issues, the jury's supposed to be deciding Mr. Prokopovitz's guilt.
all right, defendant's going to object, or?
No objection, Your Honor. I understand the nature of the instruction.
All right, 255A, state need not prove the exact date. Any objection to that?
255. It's a little, I think they were suggesting it was between the 25th and 26th, I guess. Can I just quick read the instruction, Your Honor, just so I,
Yeah.
I understand it.
All right, someone asked for 270, evidence as to defendant's character.
I think that was you guys.
State asked for that?
I believe the state asked for it, Your Honor.
I think there has been, a fair amount of evidence presented about, I guess, things that could be construed as character evidence.
Okay, so you got to fill in the blank then. Testimony has been received regarding the character of the defendant for, you got to fill in the blank, for what?
Womanizing, alcohol, gambling. Those are all things pretrial we addressed as well.
I think there's been, I guess there is some testimony to the effect that people alleged it, Your Honor. I'm not. I guess if it's limited to those things, Your Honor, I guess that was testified to. That's fine.
Can we just read this quick, Your Honor?
Sure.
We'll withdraw it at this time. I don't think we need it.
All right. 300, credibility of witnesses. 325, impeachment of witness prior conviction. And it reads some of the witnesses. I remember we had, 9 for
Right.
witness number 2. Do we have some other convictions that we actually put into the record?
Only witness number 2, Your Honor, I think was the only one that we brought up.
327, impeachment of defendant as a witness, all right, that would be out.
Correct.
330, impeachment of witness character for truthfulness.
We'd withdraw that.
460, closing instruction. Then we have 484 verdicts. And then I know we have then the verdict form, and I believe you're going to want argument on the record for that.
I think the state is just requesting that the standard instruction be followed.
All right. So we really have very little then argument for the record, correct? Is that, I think pretty much we've agreed on everything except the verdict form? Was there?
Honestly, Your Honor, if I don't mind either way, if it's one form or the modified one that you gave, or I leave it to the court how they want to handle it. I don't have a specific preference.
And quite frankly, the state's only concern is there's extensive case law regarding any deviation of the jury instructions. And that's why we're just recommending that we just follow what is recommended.
We had conducted a informal conference off the record concerning the jury instructions, and I'll read into the record what appears to be agreement by counsel. I'll let them verify that, so listen carefully then and mark these. These are the instructions counsel has agreed to: 100, 103, 115, 1010 for first-degree intentional homicide, 1766A, obstructing an officer giving false information, 570, conspiracy as a crime, 1750, perjury, 140, burden of proof, 145, information not evidence, 147, improper questions, 148, objections of counsel, 150, stricken testimony, 155, exhibits, 157, remarks of counsel, 158, recording played to jury, 160, closing arguments, 170, circumstantial evidence, 180, statements of defendant, 190, weight of evidence, 195, juror's knowledge, 200, expert opinion testimony, 315, defendant elects not to testify, 162, agreed facts, and then we've pulled the language from the two stipulations the parties have stipulated to and filed. 247, verdict as to defendant only. 255A, state need not prove exact date of commission. 275, cautionary instruction, evidence of other conduct. And then we've put in 3 bullet points from Judge Hinkvis's order. And then since his And then we have the definition for motive, intent, and absence of mistake or accident. 300, credibility of witnesses. 325, impeachment of witness prior conviction. 460, closing instruction. 515, unanimous verdict and selection of presiding juror. 525, instruction after verdict. What has not been agreed upon is the form of verdict, which then correlates with 487, verdict submitted for one defendant, 4 counts. I had provided copies to the council, and the verdict form proposed by the court is a 1-page verdict form which has 4 counts on 1 page, and a place for the defendant to plead, a place for the foreperson to check not guilty or guilty on each of the 4 offenses. State's position on the verdict form.
Your Honor, we are asking that the court do separate verdicts for each of the 4 counts, which would be a total of 8 verdicts. We do believe this is consistent with jury instruction 484.
Defense arguments.
Your Honor, I do like the idea of having one verdict form. It makes it easier. I would say that the court's proposed one. I think in the first count, we would have to take out the term domestic abuse. I believe that has to be removed. Other than that, Your Honor, I think it provides a simple form for the jurors to review versus 8 separate pieces of documentation that could be placed around. So I think it provides a concise document. So, but I leave it to the court's final discretion.
I believe the copies I provided to council yesterday have domestic abuse in. I have since deleted that out. And so the verdict form I propose to use is exactly as you see with the domestic abuse out. I understand the state's argument. I've used the single-page verdict forms in the past on cases that have had 4, even more counts. I just find that having 8 pieces of paper be handled by the jurors and the foreperson as compared to just 1 verdict form, I just find it more efficient. I find it less confusing to have the 1 document rather than the 4. I will note that I regularly and will today provide a complete set of instructions to the jurors, so they'll be going into the jury room with numerous pieces of paper. I hesitate then to give them 8 verdict forms and then have them shuffle them around. I prefer, and I believe it's cleaner, neater, and more efficient to provide the 1 form. So I'll use the form offered by the court after considering arguments by the state and defense counsel. All right, were there any form numbers that I didn't read that counsel thought should be included?
Your Honor, did you say 315, which is the defendant elects not to testify? I don't know if I heard it. Maybe I missed it.
I'll double check. I do have.
My assistant indicates that you must have, so I think we're fine then, Your Honor.
All right, I'm just going to double check this to make sure I do then.
I would like a copy of the verdict form prior to closings.
Excuse me?
I'd like a copy of the verdict forms,
Sure.
please. Thank you.
Could you have, look up at the verdict form. Yes, 315 is within the packet. I apologize if I didn't read it. It is here.
Thank you, Your Honor.
You're welcome. And then finally, while we're outside the presence of the jurors, so are we requesting they withdrawn exhibits remain with the clerk or return to the counsel who prepared the exhibits? My normal procedure, to me, a withdrawn exhibit shouldn't be part of the record.
Correct.
But unless I hear a position contrary,
That's fine.
all right, so then any withdrawn exhibits would be returned to the counsel who prepared them and not become part of the record. All right, and, did she just bring those in? Okay. And did you give each of the attorneys a copy of the verdict?
Yes. Your Honor, can we? No, it's okay.
Right.
All right.
Anything further before we bring in the jurors? So when the jurors come back, then you're going to arrest, is that the intent then?
Yes, Your Honor.
All right. Then I'll have to instruct the jurors they can no longer take notes because you can't take notes during closing arguments. Bailiff, why don't we do this? I hate to take jurors' notes in anyone's hands besides them. Ask the jurors to come in, pick up the notepads, bring them back and put them face down on the counsel table, and then return without their notepads, please. You want a complete set?
Yeah.
Sure. Then ask Marcia to call up. Apologize for the confusion. You can pick up your notepads. You can pick up your notepads, bring them back, and then put them in whatever location you want them to be. We won't be using the notepads for the next portion of the trial, okay? You can grab your notepads, go put them down, and then we'll have you come back in. Yeah, I suppose if you don't have a notepad, it's already back, you don't have to go, but...
Judge, Marcia's gonna need.
Oh, should have them. All right, counsel want to approach?
Or into the record.
All right, defense motion to admit 44. Any objection, Ms. Lemkool?
No objection, Your Honor.
44 is admitted. Attorney D'Angelo, stated rested.
The stay is resting on, and defense counsel is not going to call any witnesses. Defense rests as well.
All right. So jurors, the defense has rested, and why I had you bring your notepads back in. Here's what we have left then. We have the court reading you the jury instructions, And then after the instructions, there'll be closing arguments by the attorneys. We don't have you take notes because I read the instructions to you, and then I provide you with a copy. Since closing arguments are not evidence, we don't take notes during a non-evidence portion of the trial, and that's why we don't take notes during closing statements. I'm going to remove my mask because it's difficult for you to hear me speaking through the mask, and these are important jury instructions, so I'd like to read them to you and allow you to hear them clearer. The court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial, and the law is given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes into the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of the witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You, the jurors, are the judges of the credibility of the witnesses and the weight of the evidence. During the trial, the court has ordered certain testimony to be stricken. Oh, bring it up. Disregard all stricken testimony. Thank you. I didn't see you there. The first count of the second amended information in this case charges that the above-named defendant on or between April 25th, 2013 and April 26th, 2013 in the town of Pittsfield, Brown County, Wisconsin, did cause the death of Victoria L. Prokopovitz with intent to kill that person, contrary to section 940.01, paren 1, paren A. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. First-degree intentional homicide, as defined in section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Number one, the defendant caused the death of Victoria Prokopovitz. Cause means that the defendant's act was a substantial factor in producing the death. Two, the defendant acted with intent to kill Victoria Prokopovitz. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Victoria Prokopovitz with intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. The second count of the second amended information charges that the above-named defendant, on or about Tuesday, August 2nd, 2016, in the town of Pittsfield, Brown County, Wisconsin, did knowingly obstruct an officer while such officer was doing an act in an official capacity and with lawful authority, contrary to section 946.41, paren 1 of Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Obstructing an officer, as defined in Section 946.41 of the Criminal Code of Wisconsin, is committed by one who knowingly gives false information to an officer with intent to mislead the officer in the performance of his or her duty while the officer is doing any act in an official capacity and with lawful authority. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements were present. Number one, the defendant knowingly gave false information to an officer. A sergeant is an officer. Number two, the officer was doing an act in an official capacity. Officers act in an official capacity when they perform duties that they are employed to perform. The duties of an officer include interviewing witnesses while investigating a criminal matter. Number three, the officer was acting with lawful authority. Officers act with lawful authority if their acts are considered in accordance with the law. In this case, it is alleged that the officer was interviewing witnesses while investigating a criminal matter. Number four, the defendant intended to mislead the officer. This requires that the defendant knew that the officer was an officer acting in an official capacity and with lawful authority, and that the defendant had the purpose to mislead the officer in the performance of his or her duties. It is not required that the officer was misled. You cannot look into a person's mind to find knowledge. Knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon knowledge. If you are satisfied beyond a reasonable doubt that all four elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The third count of the second amended information charges that the above-named defendant, on or between May 3rd, 2019 and May 8th, 2019, conspired to orally make a false material statement which he conspired to not believe to be true under oath or affirmation in a proceeding before a court, contrary to Section 946.31 of the Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The crime of conspiracy, as defined in Section 939.31 of the Criminal Code of Wisconsin, is committed by one who, with intent that a crime be committed, agrees or combines with another for the purpose of committing that crime, if one or more of the parties to the conspiracy does an act to effect its object. The defendant in this case is charged with having conspired to commit the crime of perjury before a court. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. Number one, the defendant intended that the crime of perjury before a court be committed. The crime of perjury before a court is committed by one who, A, the defendant orally made a statement while under oath, B, the statement was false when made, C, the defendant did not believe the statement to be true when made, D, it is not a defense to a prosecution under this section that testimony which constituted perjury at the time it was given was subsequently corrected or retracted. E, the statement was made in a proceeding before a court. And F, the statement was material to the proceeding. Number 2, the defendant was a member of a conspiracy to commit the crime of perjury before the court. A person is a member of a conspiracy if, with intent that a crime be committed, the person agrees with or joins with another person for the purpose of committing that crime. A conspiracy is a mutual understanding to accomplish some common criminal objective or to work together for a common criminal purpose. It is not necessary that the conspirators had any express or formal agreement, or that they had a meeting, or even that they all knew each other. As long as the parties agreed or combined by their words or actions, and the defendant intended that the agreement be carried out, it is not necessary that the other person intended to carry out the agreement. 3, one or more of the conspirators performed an act toward the commission of the intended crime that went beyond mere planning and agreement. However, the act need not by itself be an unlawful act or an attempt to commit the crime. If there was an act which was a step toward accomplishing the criminal objective, that is sufficient. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that all 3 elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The 4th count of the second amended information charges that the above-named defendant on or about Wednesday, May 2nd, 2019, in the city of Green Bay, Brown County, Wisconsin, did orally make a false material statement which he did not believe to be true under oath or affirmation in a proceeding before a court, contrary to section 946.31. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Perjury, as defined in section 946.31 of the Criminal Code of Wisconsin, is committed by one who, while under oath, orally makes a false material statement which the person does not believe to be true in any proceeding before a court. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 5 elements were present. Number 1, the defendant orally made a statement while under oath. Number 2, the statement was false when made. Number 3, the defendant did not believe the statement to be true when made. It is not a defense to a prosecution under this section that testimony which constituted perjury at the time it was given was subsequently corrected or retracted. Number 4, the statement was made in a proceeding before court. Number 5, the statement was material to the proceeding. A material statement is one which tends to prove or disprove any fact that is of consequence to a determination of the proceeding in which the statement was made. If you are satisfied beyond a reasonable doubt that all 5 elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdict, examine the evidence with care and caution. Act with reason, judgment, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes into the jury room. Remarks of the attorneys are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. You have heard audio recordings and heard and viewed an audiovisual recording. Recordings are proper evidence, and you may consider them just as any other evidence. You may consider the actions of a person, facial expressions, and lip movements that you can observe on videotapes to help you determine what was actually said and who said it. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things: whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was accurately restated here at trial. Whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all the other evidence, in determining how much weight, if any, the statement deserves. The weight of evidence does not depend upon the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the way to give this opinion, you should consider the qualifications and credibility of the witness, the facts based upon the opinion, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. The district attorney and the attorney for the defendant have stipulated or agreed to the existence of certain facts, and you must accept these facts as conclusively proved. In this case, the district attorney and the defendant's attorney have stipulated to the following facts. Throughout the course of this trial, you will hear references to Kathy M. Friday. Ms. Friday was convicted of perjury, conspiracy to commit perjury, and obstructing an officer in relation to this case. Ms. Friday subsequently committed suicide prior to sentencing in her case. As a result, Ms. Friday will not be called as a witness in this matter. The items of evidence in this case, collected from the scene and from witnesses, were properly packaged, transported, submitted, and stored in a secure location at the Brown County Sheriff's Office without being changed or altered in a material way. The surveillance videos, financial records, medical records, and cell phone records were properly authenticated by law enforcement, and the defendant freely and voluntarily waives the need for the state to call a witness merely to testify to the authenticity of these pieces of evidence. There is evidence in the case which, if believed, indicates that more than one person was involved in the commission of an offense. The fact that the other person is not on trial is not material. You are to determine only whether the defendant, James Prokopovitz, is guilty or not guilty. If you find that the offense charged was committed by the defendant, it is not necessary for the state to prove that the offense was committed on a specific date. If the evidence shows beyond a reasonable doubt that the offense was committed during the time period alleged in the Second Amendment information, that is sufficient. Evidence has been presented regarding other conduct of the defendant for which the defendant is not on trial. Specifically, the evidence has been presented that the defendant's former wife, Darlene Ingalls, will testify that in the early 1980s, the defendant once held a gun to her head and the head of their daughter, Lisa Masty, and threatened to kill them. Darlene will testify that while she was married to the defendant, he was physically and mentally abusive to her. Next, Darlene Ingalls would testify that the defendant told her that if she left him, he would kill her. Next, Darlene Ingalls would testify that the defendant became very angry when he would drink, and he would be quick to anger. If you find that this conduct did occur, you should consider it only on the issues of motive, intent, and absence of mistake or accident. You may not consider this evidence to conclude that the defendant has a certain character or a certain character trait, and that the defendant acted in conformity with that trait or character with respect to the offenses charged in this case. The evidence was received on issues of motive, that is, whether the defendant has a reason to desire the result of the offense charged, intent, that is, whether the defendant acted with the state of mind that is required for the offense charged, absence of mistake or accident, that is, whether the defendant acted with the state of mind required for the offense charged. You may not consider this evidence you may only consider this evidence for the purposes I have described, giving it the weight you determine it deserves. It is not to be used to conclude that the defendant is a bad person and for that reason is guilty of the offense charged. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Evidence has been received that one of the witnesses in this trial has been convicted of crimes. This evidence was received solely because it bears upon the witness's character for truthfulness. It must not be used for any other purpose. And then when counsel approach? Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. Do you want to break or you want to go into closing? Want to go ahead? Jurors, we're just going to take a short recess then, and then we'll come back with closing arguments.
Well, Heather, do they give closing arguments from the microphones by their chairs? I mean, people know how to